Good afternoon, everyone. I'm Namita Wahi. I'm a senior fellow here at the Center for Policy Research and director of the Land Rights Initiative. And on behalf of the Land Rights Initiative and the Center, it is my great pleasure to welcome all of you to the 9th talk in the Land Rights Initiative Legal History Speaker Series. The Legal History Speaker Series is one of a series of events that we are doing in order to celebrate Land Rights Initiative's 10-year anniversary. Land Rights Initiative turned 10 on November 11 last year. And the reason why we decided to do a series on legal history is because all of our work over the past decade, whether it is on land acquisition, land rights of scheduled tribes in the scheduled areas of India, property rights, health rights, water rights, as well as our flagship project, the Mapping Indian Land Laws project, which is available as an interactive exploratory website of about 500 land laws on landlawsofindia.org. Like all of these projects show a significant continuity between the colonial and the post-colonial period. And for instance, the landlawsofindia.org website currently features land laws from all central land laws and land laws of 8 states, and of which we find that 150 are colonial laws and 350 are post-colonial laws. And also, although there are significant continuities between the colonial and the post-colonial period in many areas that we've covered, we also find significant moments of rupture. And one such moment of rupture is, in the case of the law of bankruptcy and insolvency, was 2016, when the NDA government enacted the Insolvency and Bankruptcy Code, right? So, and when we talk about bankruptcy and insolvency, what does that mean? And why have we used a legal historical lens in all of our work at the Land Rights Initiative? And why are we interrogating these important policy questions based on a legal historical lens, right? So the first is because, what we found in our work, as I explained, the continuities between the colonial and the post-colonial period, but also that many of the social challenges and political and economic challenges that we face as a nation do not find their origins just in the present moment. Many of these have been the subject of intense contestation over decades, not just, and by that I don't mean the colonial and the post-colonial alone, but like throughout the post-colonial period as well, right? And it is interesting, therefore, to understand policy questions in the present by looking at their origins and how those questions came up for contestation, how they were resolved at different periods, and how are they being looked at today. Now, when we talk about insolvency and bankruptcy, to many it appears like a very technical subject, right? But actually, when we think about it, what is insolvency really? It represents a relationship between a debtor and a creditor, right? And when the debtor is not able to pay his or her debts. That is really what insolvency is about. And when we think about it, each one of us individually is a debtor or a creditor in multiple relationships, right? So for example, and this relates to our work on property rights, we've talked about what the right to property really means. Property is a bundle of rights. And in my talk on the history of property rights in November, I had spoken about how property includes within the bundle the title, possession, use, mortgage, transfer, inheritance. And what is mortgage? It is essentially borrowing against the title to your property, right? So, and of course, property doesn't have to be land alone. We have seen it in the context of land, but property can be intangible property. And so one is the individual relationship where we have, we all have credit cards that we have to use, and we have credit card, companies, banks that are lending us credit. So in our daily lives, we are debtors till we pay our credit card, and then for many of us who are late in payment, there is a late fees, and then there's GST on the late fees. And we talked about GST in our last talk, right? So there is that individual debtor-creditor relationship that we are all engaged in. And at the same time, we also have corporate creditors and debtors. And now thinking about what we know of a company, right? So a company has shareholders who are owners of the company. And we have this separation between there's the management and the ownership of the company, right? So the shareholders are the owners. And then we have creditors who lend money to the company, often, things like debentures, bonds, etc. And so that is and we all deal with companies as well. So in all these ways, understanding how debtor-creditor relationships work is very, very central to our daily life, right? And what we find about, so bankruptcy, for example, is in all of our work. So, when I started working on the land rights or scheduled tribes and scheduled areas, there wasn't a lot of work done within the legal space. In fact, this is not an area that was even taught in law schools when, Misha and I went to law school. And what the first thing that I read in a lot of the anthropological accounts, and everyone that I spoke to, there was a lot of work that had been done by social scientists, anthropologists, is that the biggest cause of displacement of Adivasis or scheduled tribes was money lending, money lenders lending them money. And a lot of that money was being spent either for survival or alcohol. And then money lenders were depriving them of their land. So this was a huge problem within the Adivasi community. And we saw that in the way of course, our research showed that displacement, as the processes of economic development have unfolded, a large part of the displacement is also because of development projects like dams and mines, right? Also, separately in our health rights work, when I wrote this book chapter on health rights litigation about a decade ago, when we were researching that, how much Indians are spending on health, we realized that there were two factors that were essentially pushing Indians into poverty. One was health expenses, because government was not investing enough in healthcare, right? And the second was borrowing money for their daughter's wedding, thereby talking about the inherent patriarchal structure within which we are operating, right? So each of these things were pushing people into debt. So debt is a ubiquitous feature of life for everyone in any country of the world. And, when we talk about the history of the law of insolvency and why it's important to talk about it today, is because if you see from the 13th to the mid-19th century, within Europe, right, being poor was really a crime. So if you defaulted on your debts, and the reason why this is important is because when we think about England, like if we think about, the most familiar examples that we have from literature, like from Shakespeare's The Merchant of Venice, what we all know, Shylock. And although the literature obviously has these anti-Semitic tropes, but he's this Jew who lends money to Antonio and says that if you aren't able to return the money, then I will extract a pound of your flesh. And then, of course, Portia makes this argument and that pound of flesh has become like a terminology that we use to describe how creditors are, right? That is part of part of the imagination. The second example we have is from Charles Dickens' work. And Charles Dickens really did a lot in his books to illustrate how the poor were sort of criminalized and how much they suffered, whether it was, in orphanages and Oliver Twist. But he specifically talked about debtors' prisons because his own father was in prison for being a debtor in his book called Little Dorrit. And there, it's a critique of the entire system where he talks about Amy Dorrit, who was born in prison because her father is in prison for like 21 years. So you could be incarcerated for life. When we think about it, usually we incarcerate people for life for murder, right? If you don't give them the death sentence, and in India, it's in the rarest of rare cases, then people are incarcerated for things like murder. So not being able to pay a debt till about the mid-19th century in Europe was really, such a big offense. And the reason why this is important is because since 1800, obviously India was a British colony and the English colonial law was applicable to us. And many changes then happened in the 20th century. We have these colonial laws applying to personal insolvency that were still applicable today through the post-colonial period. And we had, some provisions applying to companies. Obviously, though, we needed more legal provisions to apply to companies as India became independent and took off on a process of economic development and social transformation. But even today, all over the world, actually, everyone is in debt. And here I sort of, why this subject is sort of close to my heart is because in my earlier avatar as a lawyer, when I started working, in New York was because I worked on my first major case was the Delta Airlines bankruptcy case. And if you see the entire aviation sector, every company has been through bankruptcy. But apart from that, I was in New York when the US subprime mortgage crisis happened, right? And what was that crisis about? And that is what brought about the recession of 2008. It was really about housing loans being given to people. And if you are within that sort of economic structure, you realize how people became debtors and how it was absolutely impossible for many of them to pay back their loans and what that did to the economy. So when we talk about insolvency, we are talking about the rights of people. On the one hand, how should we treat people who cannot, pay back their debts, but also the impact on the economy. And government is also a debtor. So we know that the US government has a lot of debt as well. And in fact, given that we have a new administration in the US, and the administration is making many radical changes, and people are wondering how to rein in this new administration. And there was just an article I read yesterday in the Financial Times, which was talking about how the bond market and the US debt is, because the US is so heavily indebted to, the US Treasury bonds are so heavily indebted that might be one way of reining in the administration. So debt is a big part of our life, is a big part of economy, as we understand it, is a big part of power relations. And that is why it gives me great pleasure to welcome Misha here today to give this talk. Misha is a partner in the dispute resolution practice at Shardul Amarchand. And, I have, of course, known her for nearly a quarter of a century. And, we were contemporaries in law school. I was a year ahead of her. And, she's had a very long and illustrious career as a litigator since she joined Shardul Amarchand right after law school. She has 19 years of experience appearing before the Supreme Court, pretty much all the high courts, arbitral tribunals, and company law tribunals in relation to a wide array of commercial disputes. And she has been recognized nationally and internationally as one of the country's leading bankruptcy and insolvency lawyers. She has been involved in the resolution of 10 of the 12 largest non-performing asset accounts referred for insolvency by the Reserve Bank of India under the new bankruptcy law. And of course, if you think of some of the major cases where she has represented the Committee of Creditors, and she will obviously talk about the insolvency processes under the new law, initiated against Essar Steel before the Supreme Court, and she has successfully resolved many of these non-performing asset accounts. Also with Amtek Auto Limited and other group companies, and before the Supreme Court in a case involving complex questions of law relating to emerging jurisprudence in respect of the IBC. And she has also represented ICICI Bank Limited in the corporate insolvency process against Jaypee Infratech Limited before the Supreme Court. Also, the Educomp group company's insolvency resolution, she represented the Committee of Creditors and successfully litigated the issue of whether a resolution plan can be withdrawn after it has been approved by the Committee of Creditors. And of course, she will explain what that means to us. So this is just a short snippet, but she has basically represented either the creditors or other stakeholders in many of these very important bankruptcy cases, corporate bankruptcy cases that have come up before the Supreme Court and the NCLAT, the National Company Laws Appellate Tribunal. She has been recognized for her restructuring and insolvency practice by Chambers and Partners Asia Pacific 2024, and recognized as one of the top 100 women in litigation in India or in Asia Pacific by Benchmark Litigation, and a 40 under 40 rising star by Legal Era. What I can add to that is just to say that, I was Misha's teaching fellow in one class, which was a class on jurisprudence. And I think that apart from all the accolades that she has managed to gather over her long and illustrious career and has become an inspiration to, I think, all lawyers, is the fact that, I remember that she picked a very unusual topic for her jurisprudence class. And it was on the principle of writa in Indian jurisprudence or something, what I recall. And I think that probably characterizes her career. She's always looked for the unusual and something that nobody's working on. So when she started in 2016, The IBC had just come into force, and now actually a decade later, I feel like this government has amended all the laws. So we are all sort of starting over. But in 2016, it was the IBC, which was one of the biggest reforms that had happened. And basically, they have invented the jurisprudence as they have gone along. So uncharted, territory. And hopefully 10 years later, some charting has been done of the territory. So without further ado, a very, very warm welcome to you to come to CPR and, enlighten us about personal and corporate insolvency.
Thank you so much, Namita, for having me here.
That one also has to make it.
So, I've been a litigator all throughout my life as a lawyer. So coming to an institution like this gives me, a moment to take a step back and reflect on what laws I've been dealing with, what impact it has on us as people, on our economy, on our country, what can change, what's better, what has not worked. So I truly value that opportunity to be able to, look at all of that and share my views with all of you. And, happy to, of course, make it an interactive session and be answer any questions. Of course, there's a lot in insolvency and bankruptcy codes, and those who are not familiar with the subject, I would try and make it simple. But just in case I skip some detail, please feel free to ask me a question. And when I looked at this whole session, I thought let's look at first the key objectives of an insolvency law. Test against that, look at the erstwhile insolvency laws in India and test them against those parameters and see where we were. And then look at IBC and where it has taken us. And lastly, I would like to also touch upon some of the significant issues which are still pending a kind of resolution and way forward. So, UNCITRAL legislative guide is a good source for you to make looking at, what are those standard touch points which an insolvency law should be with. And as what is it? Failure or inability to pay your debts, and how do you deal with that situation, and what should law do, and what framework should law provide in that situation. So the first value is that there should be certain certainty in the market which promotes economic stability. So while we do have debtor creditor relationship between an individual and the banking institution or a lender, there's debtor creditor relationship amongst between the large corporations, companies, and lenders as well. Now, they may not directly seem to be something which affects me, but it does, because it affects the economic stability of the country. That very bank or financial institution is also going to give the student loan or the housing loan. And if they are under stress because they are not able to recover because their borrower has defaulted, it in turn affects the common man as well. So while I would touch upon some of the aspects of personal insolvency, which hasn't been fully operationalized yet, and we still have colonial laws in operation, but what we have seen under IBC is primarily the working out of the company related insolvency law, and we'll see how it has really affected us. But when you provide this certainty, I think the key value is that you should be able to allow a viable enterprise to go on, and you should allow an unviable enterprise to exit. It's as simple as that, right? And that's very important, that the law facilitates something like this, right? This will in turn facilitate, the creditors being able to lend money to startups, fresh entrepreneurship ventures, right? The capital should not be stuck in unworkable assets. It should free itself up, either the business, whether it's in the form of a company or a proprietorship, either it should revive or it should wind down. The second value is maximizing the value of assets, right? And I'll touch upon this as a specific one of the values of IBC. But broadly speaking, we are looking at that you take as much value out of the assets of a failing business so as to distribute amongst all stakeholders the maximum, right? And you have to also balance the risk associated with insolvency. When there is an insolvency, their employees, their workmen, their customers, there's the business itself, there's the lender. You need to also decide for yourself as to how you're allocating those risks. That's also a function of insolvency law and needs to be spelled out clearly. The other aspect is striking a balance between liquidation and reorganization. It should not be that forever you're trying to revive a dead horse. And it should also not be that, straight away you push anything under distress into liquidation. The next one is ensuring equitable treatment of similarly situated creditors and recognition of existing creditor rights. So when I lend money to any enterprise or any individual, I do it on the basis of a credit risk assessment as to how much risk I see in terms of, in this portfolio, say I have extended 10 loans for student loans, how much risk do I have in terms of somebody not returning it, right? So on that basis, you negotiate certain rights. When you extend a home loan or you extend a working capital loan to a company, you typically look at either a higher rate of interest because your risk is high and you don't have any avenue of a collateral like a mortgage or a security interest like having a right over the cash flow of the enterprise. If you don't have that, typically you'll have higher rate of interest. But if you have access to security, you have the ability at the, on the basis of having that backup, that if you are not able to pay me, okay, I'll go and take your property and realize my dues, you are able to extend credit at a lower rate, right? Now, these bargains need to be respected in insolvency because that's where they really come to test. Because if I'm going to be able to repay all my loans, none of it will come into operation, right? So that certainty of you being able to enforce your rights against the borrower at the time of insolvency is very crucial for especially the lenders, right? Then, of course, goes without saying timely, efficient, and impartial resolution. You need to act fast in a situation of distress because sometimes the business is capable of revival, but it needs little additional capital. It needs maybe change of management, or it needs a bit of debt restructuring where the lender gives up some haircut and, gives a longer period of repayment that allows the breather for the enterprise to survive. Or if it is reached a point that there is something which cannot be corrected about this business, then you need to wind it down. So you need to do this in a very timely manner. For that, what should law provide? Law needs to provide for objective criteria for admission into an insolvency process. It should be very objective so that the process can get kick-started. Otherwise, you'll keep arguing in courts, which happened in the earlier regime. And then you should also have to identify, collect, and preserve these assets, right? You preserve these assets usually by way of a moratorium, where you basically say that if an entity is under insolvency, you will not take any coercive action against them. You will not go and recover your money from them, right? Then lastly, is also framework for cross-border insolvency in today's modern world of global companies having operations across continents. It is important to have a cross-border insolvency framework so that you could also trace assets, seek cooperation in other jurisdictions. Now look at our erstwhile regime in context of all these parameters. What did we have? We had SIC Industrial Companies Special Provisions Act. This was for corporate rescue of industrial companies. It only applied to industrial companies because that was the era where the manufacturing was the key driver of our economy. Then there was Companies Act itself, 1913 and 56 and 2013, which essentially provided one for winding up and also for reorganization in the form of scheme of arrangement and amalgamation, etc. Then there were two insolvency laws, Presidency Towns Insolvency Act and Provincial Insolvency Act. Basically, one law applied to presidency towns and the rest of the country, which governed the individual insolvency, right? And lastly, the latest of them is the Limited Liability Partnership Act, which also has the provision for winding up, dissolution, compromise arrangement in context of LLPs. Now, these laws often interplayed with two, three of key remedies of the financial creditors or lenders, if I may say, at this stage, because ultimately, if a company or a business goes into gray zone, the biggest concern is that of its creditors to recover its money, right? So there was SurfAC, which was actually a response to SICA's failure, and I'll come in a minute to why SICA didn't work, which essentially allowed secured financial creditors and banks, it's only to institutional creditors, to enforce their security interests like mortgage, hypothecation, etc., outside the court. You didn't have to go to court. You just had to issue notices, pay up. If they don't pay up, then issue another notice for possession and then go ahead and sell. Of course, there was remedy of the borrowers to go and challenge at the stage of sale and at the stage of possession. But before that, there is no challenge, right? So the idea was that this is contracted out, you have this security, the borrower is not able to pay, you go ahead and realize your dues by selling whatever the property is. It had a very limited success for the reason that you needed something very liquid kind of security, which you would be readily be able to one take possession of. Like, something which the borrower is in possession of, they would literally not allow you to take even symbolic possession of, for which the law had provisions for, magistrates help, etc. But effectiveness, it does take away the effectiveness. The second part is that even if you take possession of the asset, there may not be readily available buyers for it. So there's only that much you could do with SurfAC. There was also provision in SurfAC for you to take over the management of the company itself if you had substantial security over the assets, but that was rarely used because it exposes the creditor to a lot of liabilities in terms of running the company and all, which a lender is not equipped to do. Then there was also Recovery of Debts and Bankruptcy Act. It is called, earlier it was RDDB Act, but now because of the bankruptcy law, it's been amended a bit. But it is essentially allows banks and financial institutions an exclusive tribunal to go and agitate your recovery actions against the borrowers. Unfortunately, the debts recovery tribunal hasn't been that efficient, has degenerated over time. So the law hasn't been that efficient as such. Lastly, there were RBI governed non-statutory debt resolution mechanism, which basically enabled the lenders to form a joint lenders forum and agree that, okay, there's a genuine business problem right now. We want to restructure this loan. Some of us want to exit and take a one-time settlement, right? And some of us want to continue in the company with larger exposure, or will give them more loans to continue. So you did that negotiation on the floor of the lenders. Now, this was not really binding. This was non-statutory. It was guided by the RBI mechanism, but all of that, actually the RBI mechanisms have been kind of withdrawn in view of a comprehensive law that the IBC became. What happened because of this regime was this, that as you could see, there were so many laws operating in the field when a borrower is unable to pay the debt, right? This is in addition to a civil suit remedy of somebody going against you and filing, right? So what it did was that there was a lot of interplay and conflict between multiple laws governing insolvency and debt recovery, taking you to prolonged litigation reaching the Supreme Court often, right? So you will have those judgments settling SurfAC versus DRT, Companies Act versus SICA. So, lawyers had good business settling it all through the Supreme Court, but the true actors in the insolvency were suffering because of the delays and confusion. Now, there was no framework for revival of distressed corporates except for industrial companies. So that was completely lacking. Now, SICA, which applies to distressed company, was the only law enabling restructuring, but had many flaws. One, it could be triggered only on complete erosion of the net worth of the company, right? Now, if the entire company's net worth is gone, what is left for you to revive it? So the trigger itself was extremely late and improper. The second was moratorium provision under the law protected the promoters. This was a debtor in possession model, where debtor continued to run the company and there was a moratorium. Nobody could come and file anything against you. Everything was before this board for industrial and financial reconstruction. And the result was just deliberate delay on the part of the promoters. And in the meanwhile, basically taking off and stripping the company of all assets. You're not able to really recover much out of it. And who benefit was to the promoter, and it was not to the company. The company didn't survive. It was the promoter on the management which kind of got away with the crimes of the era in England and all, right? So that it was a very, very friendly, debtor friendly model. Didn't work. Then you look at Companies Act. Companies Act trigger was that you could providing for winding up that inability to pay debts. It was by definition a subjective test, and you had prolonged litigation on whether winding up needs to be admitted or not, right? And it was only being used by the creditors as a negotiating tactic. If some promoter wanted to save the company, they would come on the table and under the threat maybe give them a settlement. Otherwise, you keep fighting over it. The second major flaw in the winding up regime of Companies Act was that there was no reorganization or revival happening there. It was straight taking you to liquidation. And in liquidation, it did not incentivize the secured creditors who had security over the assets of the company to participate in liquidation. So somebody went to DRT, somebody went to SurfaceC, and they just enforced their security, sat pretty tight on what they could recover. There was nothing left in the company for you to even liquidate, right? So that was another problem. Then there were personal insolvency laws, which were archaic, which Namita very aptly in the very beginning set the context to insolvency law, especially for individuals, that it was like a crime, right? If you are not able to pay your debts, that's the end of the road for you. There was no concept of discharge of debts. There was no orderly exit from the situation. You are an entrepreneur, your business failed, you're not able to pay. Yes, there were protection that your house or utensils could not be taken, but beyond that, it was a never-ending process, right? And uh, and obviously, it had the social stigma. And the process also lacked the expertise of an insolvency professional and was debtor driven with minimal role of creditor. So there was no solution to it, right? So that's where we were in the erstwhile law. Now, of course, you could see it's an unpredictable outcome. It is not fulfilling the very first parameter of a predictable, framework. Did not maximize the value of assets. They're just stripping off assets either by promoters or by the secure creditors, and you're not maximizing the value. There was no balance between reorganization and liquidation. We hardly had a framework for revival. Then you fail to provide timely, efficient, and impartial resolution, fail to adequately preserve the debtor's asset. And of course, there was no cross-border insolvency, which we don't have till date, but that's fine.
You want to explain the difference between promoter and management?
Right. So promoter would be somebody who is in the capacity of shareholder, started off the enterprise, put in the initial capital, right? And would be either an equity or a preference shareholder kind of a person. And promoter within that category is also somebody very specific who started the business, right? There can be other shareholders who come in later, they are not promoters. Then there is management, which is like, the board of directors, the professional, the key management persons like your CFOs, CEOs who are driving the company. Now, every company may have a different model, right? Sometimes it may be very promoter entrenched. Sometimes it may be professionally run as well. So, and it's an important distinction keeping in mind to even understand how IBC works. But that's how it is. But yeah. Right. So preference shareholders is essentially a class of those shareholders who have preference over the rest of the ordinary equity shareholders. So if the company was to be liquidated, and if there was any balance capital left or money left for being dividend to be paid out to the shareholders, then preference shareholders literally get the preference over the equity. And they also have, depending upon the terms of the preference shares, also have preference in terms of payment of dividends, etc., when the company is normally running as well. Now I want to just very quickly go to IBC. I want to give you a quick overview of what this law does. it sets out in rehabilitation, revival, and insolvency procedures for all corporate debtors as well as individuals and partnership firms. So that's what first unique feature of IBC. This is one consolidated law which deals with every insolvency situation except for, say, HUFs or trusts or financial service providers, which it doesn't cover. But by way of an amendment, the NBFCs having asset size more than 500 crore or more have been included. The idea is that financial service providers are essentially your banks, financial institutions, NBFCs. It was intended that they should have a specialized law to deal with their insolvency because they're backbone of your economy, right? If they go bust, the banks go bust, the public depositors, everybody's money is gone, right? So you don't want to deal with banks or financial institutions in IBC. So as a original design, they were not part of it. But because that law has been in the conversations and discussions and has been shelved for the time being, and there were some pressing, NBFCs which needed to be resolved. So that is how, that exception and amendment was brought in. But strictly, IBC is not for, financial service providers. Then the provisions related to personal insolvency, other than those relating to personal guarantors, have not been operationalized. So if you are a guarantor to a corporate, then all provisions in relation to IBC are operationalized for you. All other individuals, partnership firms, unregistered partnership firms, they are not covered under IBC yet, although we have a law dedicated for them. There is an institutional infrastructure which has been put in place with IBC. You have an insolvency regulator called Insolvency and Bankruptcy Board of India, which is very, very active regulator, which is consistently looking at the law, framing the regulations, amending the regulations, having discussions with the stakeholders, how to improvise this law. Then you have a single specialized tribunal called National Company Law Tribunal to hear the matters. Then establishment of something called information utilities. The idea is that whatever debts that the company or businesses take from banks and financial institutions or other creditors, they should be recorded in information utility so that when I, as a creditor, go to NCLT and say that he or she has defaulted, just the record of information utility can be used. It has been operationalized, but it's taking time to be the only source of proving default because, it's still a work in progress. Then you have a cadre of specialized insolvency professionals. Anybody can give that exam and become an insolvency professional, or you are an accountant or a lawyer with a certain number of years of experience that you are entitled to become professionals. In our experience, mostly it's accountants or advisors or, big fours like Deloitte, PFC, EY, who are doing work in this in this area, or there are also international entities like Alvarez and Marshalls who are specialized in dealing with distress situations. So they know how to take care of the business during this time and run the insolvency process. Then it provides for a time-bound integrated reorganization and insolvency process and a creditor-driven process with limited judicial intervention. So in that sense, today this law is very much heavily towards the creditors. I represent the creditors, so I don't really complain about it. But I'll try and give you an independent perspective on this law. But of course, my experiences and a lot of my learning is from the creditors' side. So you can take it with a pinch of salt, and there are certainly other perspectives to it. But I'll try and cover fairly as much as I can. Now, I don't want to just go too much of detail into how it works, but I'll give you an overall snapshot of how it works. So firstly, it asks for early detection of distress and easy trigger. So if you have defaulted on 1 crore loan, your creditor can take you to insolvency, right? So that's the early objective criteria, not inability to pay debt or something, or sickness as was in Sika, right? Now, just here, before we go into too much of detail, IBC has provided a very unique categorization of creditors. See, world over, you would typically see and hear about categorization as secured creditors and unsecured creditor, basis who has a security interest to guarantee essentially that loan, and those who don't have. But what IBC does is creates a category of one, financial creditors, and second of operational creditor. And frankly, there are other creditors which initially in the design wasn't thought about. But financial creditors are nobody apart from essentially who lend against time value of money, right? They are your lenders. Any kind of loan or lending transaction, through bonds, through debentures, through loan, this thing, working capital, they are your lenders. They typically this will involve interest, but by definition, that's not necessary. Even if it is a repaid in one bullet repayment with a coupon rate or something, it satisfies the time value of money. What it basically means that I am parting with my money to you, and there is a time value to that money because the money earns itself, and that because I have parted with you, you will compensate me for the time that you've borrowed that money from me. So that's financial creditors. And the idea of, and let me first cover operational creditor. That basically includes four categories. One is workmen and employees. The second is your creditors who have provided you goods or services. Third is a government, right? Any kind of taxes, dues, etc., which are payable to the government. So these are the categories which are included in the operational creditor. Now, the reason for this distinction is this, that the framers of this IBC wanted not only secured creditors to be voting on whether the company should resolve itself or it should be liquidated. They wanted even the unsecured creditors, financial creditors, to have a say, because ultimately they have provided the capital for that business to run. And it is their commercial decision whether this, and their commercial assessment whether this company or this enterprise can go on or not go on, whichever format, company, LLP, or even a sole proprietorship. Now, while doing so, the idea was to give impetus to our bond markets, right? So that we can raise more money and there can be more, economic activity in the country. Now, operational creditors were kept aside, and why they have combined government with operational creditors is because there is a very conscious decision of the government to take a hit in the priority of dues. So when liquidation happens, when the company is wound up, the proceeds are distributed amongst the stakeholders in a priority. Earlier, the crown debt was amongst the the highest, along with the secure creditors and all, right? But here under IBC, the crown debts go under priority number 5. Okay, what they say that firstly you pay the insolvency and liquidation costs, then you pay the secured financial creditors along with the workmen, and then you pay employees. There's a different categorization between workmen and employees, and those also dues are not unlimited time dues. Those are dues only for 24 months for workmen and 12 months preceding the liquidation commencement for employees. The idea being that they have also given a right to an employee or workman to initiate insolvency. So don't sit on your rights for beyond 24 months. When somebody has not paid your dues, take that company to insolvency yourself, right? So that's the balance they tried to strike. And after that comes unsecured financial debts. They get paid, and after that the government gets paid, right? So that's the reprioritization they have done consciously. In this context, they have done a creditor in control model where the financial creditors dictate how the entire process is to be run. They form a committee of creditors. An insolvency professional is appointed and it displaces the board of directors. And he runs the company, and he also runs this insolvency resolution process, right? Corporate insolvency resolution process, we call it CIRP, right? So what that person does is that call for all claims, invite for the resolution plans, put out an information about the company, and see if somebody wants to come and take over this company. Or even the promoter can give a plan, as long as they are not disqualified. There are certain disqualifications under the IBC. In this committee of creditors, the operational creditors don't have a say. So ultimately, whether the company gets liquidated or gets revived, what kind and whose plan gets approved is in the hand of only financial creditors. The protection which is provided to the operational creditors is that it says that they will be paid at least their minimum liquidation value. Now, it's a fictional exercise that if this company was to be liquidated, what will workmen get? What will government get? What will its trade creditors get? That you have to pay for sure. Rest, whatever is coming, the financial creditors can take in their hand. And then it also provides for an equitable treatment of creditors, because it says that if they are differently placed in lenders also, somebody is secured, somebody is super secured, somebody has less security, then you can take that into account while deciding that out of 100 rupees in a resolution plan, 10 will go for insolvency costs, 50 will go to secure creditors, 10 will go to a inferiorly secured creditor, and 10 will go to the unsecured financial creditors, and in the process, operational creditors may or may not receive anything. Now, the other key feature is that it is time-bound process for maximization of value. See, the key concept, and I think that is where there is a bit of confusion in IBC and even in the jurisprudence which is emerged under IBC, that they talk about time-bound and they talk about value maximization. On the name of value maximization, the COC, the Committee of Creditors, keeps saying, oh, we have got one more bid. It has come beyond the timeline, but he's giving us more money. It is the purpose of law is value maximization. So please allow me. And with respect to my clients, their corporate greed leads to delays in the process, right? But the value maximization is not meant to be seen in that way. Value maximization of the assets of the corporate debtor has to be in a very time-bound decision. You want it, you want to resolve, you preserve the asset and don't let the assets get dilapidated, and you make a solution quickly. So that's still something where the jurisprudence is emerging, and I may be in the minority. Sometimes people have looked at value maximization. As long as you get a better plan, you're allowed to look at it, even if it breaches the timeline. The other key feature is that there are no prescription on solutions to resolve insolvency. Now, this decision has been left to the Committee of Creditors. What do you want to do with the company? You want to give them a one-time settlement? You want to sell part of its assets and you want to revive rest of the company? You want to, convert the debt into equity for the lenders? Whatever you want to do, you can do. It's not a prescriptive law. See, it's a very enabling law. It provides for a framework in which the stakeholders are supposed to take responsible decisions, right? Now, if you measure against that, I think it measures up very well against the UNCITRAL legislative guide keys. It does provide a framework for you to choose whether to revive or to, liquidate. It does provide for maximization of value. It does provide a balance between liquidation and reorganization. There is a very clear rule for ranking of priority claims. I'm saying so, it's on the paper. It's been interpreted and a lot of confusion has come. But in my opinion, the law does provide that. It does provide for equitable treatment, orderly, timely, and efficient resolution mechanism, and preservation of debtor's estate, because there is a moratorium that applies, and an insolvency professional takes over and makes sure that there is no leakage from the system, right? Of course, the cross-border law, insolvency law is currently pending. That's something which we still have to do. But let's look at on the ground what IBC has done. It has brought in a financial discipline. And we need to remember that IBC has been implemented in context of companies. These are large borrowers with sophisticated promoters and shareholders. And it has helped to bring in a discipline, by changing from a debtor in possession to creditor in control. The creditor today is able to prevent leakage, is able to bring the promoter to the table, right? There's also compliance on the ground because there is an effective remedy. They have been biggest of the promoter families have been displaced from the largest of the companies in this country through IBC, right? So they're not taking the system. The example would be Essar Steel for sure, that by itself. Then, all of these big 12 are all of them where the promoters have been Bhushan Power, Bhushan Steel. The promoters have been, removed, and completely outside entities have taken over. Binani Cement. So all this has been very, very productive in that sense, right? then there is an increase in investor confidence. Like, because we cater to the corporate clients, we know how much interest there is in the India as an economy because of this law for investors to figure out whether they should be coming in. India is anyways a growing economy. There's a lot of interest in India. But with a framework like this, it has helped, to boost the investor confidence, because there is some predictability and outcome. It is not that there is a timeline of 180 stretchable up to 330. It doesn't happen in that much time. It takes about standard 600 days. But it is still better than nothing happening over innumerable years, which was there in the past, right? Then increased ease of doing business and entrepreneurship. uh, it also allows people to exit, right? Like, we get so many queries for people coming today and saying that we have not been doing business, we want to wind down and exit, right? It was not that easy earlier. Now it is possible, and there are checks and balances. They cannot really cheat their creditors and go. They have to pay up all their dues and they can exit. Then, of course, there are strengthened rights of creditors, which has really helped. And the reason why it affects the common man is because if a bank is able to better realize its outstanding dues, it is better able to allocate itself in other, non-corporate, portfolios as well, right? If its capital is stuck in large businesses and companies, have and focus on retail banking and other stuff. So I think it overall generates a positive economic cycle. Then I think we've kind of spent some time on maximization. Let's look at balancing the interest of all stakeholders, which is another key objective of IBC. What does it mean? It doesn't mean that everybody is equal. And at some point of time in our jurisprudence, in context of Essar Steel, actually that is what happened. Our NCLAT treated everybody equally. Workmen, trade creditors, government, secure creditors, unsecured creditor, partly secured creditors, everybody equal, everybody just getting a equal share in pie, right? That was problematic, and we'll talk about how it was resolved. But the way it is done is workmen and employees rank first in the priority list and typically paid in full. When I say rank first, I've already told you that first insolvency and liquidation costs, then workmen along with secure creditors, and then employees. So they're quite in top, because that's our policy objective, that workmen and employees need to be taken care of in the situation of insolvency. They may not have a contractual right to get priority, but statute provides that. Then it is coupled with their right to initiate CIRP and benefit from continued employment if the company revives, right? Because now there is a framework which allows you to revive a company. So the workmen will have continued employment. Then operational creditors have a right to initiate, though they do not have a seat in the Committee of Creditors. We spoke about that. Benefit from continued operations upon revival of company, coupled with the protection of liquidation value, which we spoke about. Financial creditors have a right to and make key decisions regarding the corporate data. Treatment of secure creditors is currently undergoing interpretational challenges. We'll come to that in a bit. But what BLRC, the Banking Law Reforms Committee, said about shareholders was that nobody has a divine right of ownership, right? If you have started a company, you are the owners, but you have taken loans and you have defaulted on that. On default, that the control shifts to the creditors, sorry, right? And of course, this entire thing, so if you look at US Chapter 11 or something, 6 months, I think, is given for the promoters itself to try and revive, right, with moratorium. But here, because our experience in SICA has been so negative and it has been misused, we have in that sense swung to another side of the pendulum, where on the day start, we say, okay, you are not in charge. Now somebody else will come, insolvency professional will come, and creditors will direct them. So that's where we are in terms of balancing each of our stakeholders. Personal insolvency, unlike the previous regime, it provides for an easy exit for individuals without stigma. So there is a process called fresh start. It is like very minuscule, few thousands of rupees of your debt can just be written off as long as it falls in a certain type, so that all you need to do, it is not operational yet, but the idea is that if there's small farmer loans or things where you're not genuinely able to pay and you don't have otherwise an asset size beyond to really liquidate and pay off, you will be really, there will be a loan waiver, you can do a fresh start. or you could do an insolvency resolution process similar to a company, to the extent that there would be an insolvency professional appointed who will help you draw up an insolvency resolution plan, where they, you sit across the table with the creditors, you look at what the ground reality is, you look at why the default has happened, and if it's a genuine business failure, maybe give some haircut and let the person go. If creditors don't agree, then you go into ultimately to bankruptcy, where also after discharging the debts which your estate can, you will get a discharge. It's not that you are stigmatized for the rest of your life. So that's the purpose of personal insolvency law, which is yet to come into being. But the idea is to move away from that, right? And there's only one flaw in that, law, which is very, very clear. It is in operation only in regard to personal guarantors, which happen to be quite sophisticated individuals in most of the cases, because they are guarantors to the big companies at a lot of times. What happens is, the moment that application is filed, including by yourself as a guarantor, there will be an interim moratorium which prevents all the creditors from taking any action against you, even when the insolvency action has not been admitted by court. And ironically, there is no restriction on you as an individual from frittering away your assets. So I think there's a clear, drafting error there, which needs to be resolved, but we've been talking about it. Hopefully it will come. Let's from here move to some significant pending issues. I think treatment of operational creditors, I would like to spend some time, because for a lot of people who look at IBC, and a lot of lawyers as well, I have come across, who say that it's very unfair. They don't have a right to vote. They have no ability to influence the outcome of insolvency process. And on the name of liquidation value, they get nothing, right? And the Committee of Creditors only look at their own personal thing. And this is extremely unfair. And you are looking at these trade creditors are the majority of MSMEs, which are like 40-45% of the 45% of the Indian economy, right? So you are actually, jeopardizing the whole economy by, leaving them high in the insolvency process. So that's the criticism to the law. In the recent past, what MCA has come up in 2023 a notice, which says that after secure creditors, we'll treat everybody, right? Including financial creditors, unsecured financial creditors, government and everything, so that they get little more.
MCA is the
Ministry of Corporate Affairs. Now, the idea, this is actually, okay. So the idea was to, to change this. This would then basically take you back to a traditional model of distinction between secured and unsecured, which we have moved away from. The alternate view is, and this is just a food for thought, that OCs have the power, one, to initiate insolvency proceeding plus minimal liquidation value. They're not really worse off than any other law, because that is what they would have received in not ordinary liquidation as well. The reason they were not given decision-making powers was because they are not equipped to decide on these issues, whether the company should survive or not. So these operational creditors would also be a truck drivers association, right? Or truck operators, right? Or they would also be workmen. They may not be empowered to do, may not have the wherewithal to do it. Then OCs have the bargaining leverage to restrict or terminate their contracts. So if they're not paid for a while, they can always choose not to do business. For a financial creditors, they're out of pocket ones, right? They have to only retrieve that money back. There's no other way, right? Then also there are studies which, we had relied in Swiss Ribbons and Essar to show that there's a higher profit margin for operational creditors, whereas FCs operate on a very thin margin of 2 to 3%. So they really have to, for their economic health, retrieve their money, recover their dues. Otherwise, it's very difficult. And OCs benefit from continued business operations. I'll just leave you with one statistic data here. In Essar Steel, there was operational creditors during the 600 days of insolvency who paid 55,000 crores because the company was continuing during this regime. And financial creditors had to forsake interest during that period because there is a moratorium, and they lost 17,000 crores. So in the end, operational creditors got only 20%, and financial creditors got about 92%. But see how much they benefited because the company continued during CRP and will continue to benefit because of beyond CRP. Now, so that's, I think, some of the aspect I wanted to. The other aspect, maybe very quickly, I would mention is that what has happened, and I'll not go into case law, is that there have been consistent dilution of rights of secure creditors. First in Essar Steel, when they distributed everything equally, then the amendment came, then the Supreme Court intervened and they said that you can distribute in reference to security value. Subsequently, there's a judgment of the Supreme Court in India Resurgence, which said that when you calculate liquidation value of a secure financial creditor, you don't have to take into account their security interest. So that's quite, I personally feel it's an incorrect decision. Subsequently, the Supreme Court and Ruchi Soya has doubted the correctness of India Resurgence and it's been gone to the larger bench. And in liquidation context also, they have interpreted Section 53, which provides distribution waterfall, to say that once you relinquish your security interest, you want to give it to the liquidator to realize, then you will not have interstate security. Now, all of this actually goes against the basic principle of law and the parameter which we spoke about in ancestral model law, that you honor the pre-bankruptcy entitlements, right? If you don't honor that, then what happens is brings in a lot of unpredictability. You don't know, even as a secure creditor, whether you should lend at a lesser rate because tomorrow the courts are not going to look at your security. The other aspect I wanted to very quickly highlight is that real estate sector, there have been some amendments in the IBC for this. They have made home buyers as financial creditors, which I personally feel is legally incorrect. It was a call for the policy because they wanted to, really not ensure that the creditors take away the money and home buyers are left without their flats and houses, which is an understandable policy objective. But in terms of a framework of law, they're not strictly financial creditors. So what is happening is that there's a lot of amendments being made into IBC to cater to real estate. There's a judicially crafted reverse CRP. Basically, the company goes into insolvency and you give an opportunity to the promoter to take it back, right? And come up with something. Or IBC only envisages company level resolution. They have provided project wise resolution. So plus what also happens in real estate companies is that the land is somewhere else and the project is somewhere else, right? And if the land owning company is not into insolvency, then how do you really resolve that entity? So strictly speaking, IBC standard procedure is not suitable for real estate and perhaps needs a specialized law. The other difficulties are gaps are that we don't have a cross-border or a group insolvency framework. I personally feel that it is not a very pressing demand. It should come with time. There are other pressing demands like sorting out our jurisprudence on secured creditors' rights, because I think that's so fundamental to insolvency law framework that if you get that wrong, the economy, everything, just reality changes. This one is a work in progress and I'm sure it will come, cross-border and group insolvency as well. Delays, of course, everybody is talking about it. It is a cause of concern and I think the law is fine, but its implementation needs to be improved and we can do better. So I'll just end here. I think I've taken a lot of time on this.
Thank you so much. But let me just pick up on what you said about delays, because I just got an email about exactly this issue, that for mergers and acquisitions to be approved, they need mergers and acquisitions of companies to be approved, they need approval from the Competition Commission as well as the NCLAT. But the NCLAT apparently has 19,000 pending insolvency cases, and that's creating a big problem. So I think if you want to elaborate on the delays and what that means, and actually, so it's been 10 years, right? And you have really very extensively mapped out the positives and the negatives. So where are the main blockages now in terms of insolvency resolution?
I think the law is fine and the framework is fine. It is in the implementation that we are lagging. And as one of the stakeholders in that ecosystem, I am equally to be blamed because we lawyers are equally, serving the interest of our clients by, causing deliberate delays. The truth is that yes, NCLTs are and NCLAT are clogged with a lot of matters. So it does help to, have more judges and the vacancies being filled. But more importantly, I think it's also about the quality of justice dispensation. With much risk to me being a practicing lawyer, I'll still say it's lacking in those forums, right? There are of course exceptions, but in the majority, there's lack of discipline and there's lack of engagement from the bar and the bench in getting it done soon. And I feel we took off very well when IBC started. It got operationalized in 2017 and everything. And NCLTs really ran with this. And if you were to take this kind of load of work even to your constitutional high courts, it would have been a challenge because, in high courts, typically you get a date to 2-3 months down the line, right?
Yeah.
But NCLTs did fantastic job. But I think when COVID set in, and we were still working during COVID, right?
Yeah.
And we had virtual hearings. But I think when we came up with this whole thing of extension and exclusion of time, that whole sanctity of timeline went away somewhere. And now it's being treated as that it's fine. The other thing is that, we don't have any longer those kind of pressing NPAs, right? The large companies have been resolved. So the ones which are in insolvency today are mid-tier companies. So I think we are just not taking it seriously enough. We're not putting the effort enough. Of course, there should be more support. There should be more judges. But it's just on implementations. It's not, the framework is not lacking.
So I'm going to open up the floor to questions. Do we have any from people in the room or on Zoom? I think, yes. Karan Devakaran, do you need a mic?
Heard a lot about asset reconstruction fund which is being generated, and now there are some companies also, reconstruction companies.
Right.
Are they of any use in that resolving this NCLT issues? And then one more question is like you said most of the big firms NCLT or that insolvency has been like, there are something like Future Group. What about because that is also, I feel it's a big company. They are still in that, their process has not been completed.
Right. No, you're right. So firstly, for ARCs, definitely they have a role. And they have a role within the law, IBC, and outside the IBC, because they're designed to take, say, NPAs over from banks and financial institutions, which can't possibly, carry on with such huge backlog and NPAs. And then they have that expertise to turn around, sit with the management, come up with, alternative funding mechanisms and everything. So they are doing that work, and a lot of them are doing significant work in this space. A lot of it is outside IBC itself, right? It's in the restructuring space. The other aspect is their role as, say, potential resolution applicants. Now, there's been a bit of regulatory uncertainty, but that has also been resolved by the RBI. There was earlier a question whether an ARC could be, resolution applicant or not. Now, the RBI has put down certain parameters. You need to have certain, asset size, etc., to be able to be a resolution applicant. So they have a play there as well. But of course, that restricts the number of players from the entire ARC segment because only those who qualify can do it. As regards Future Group or other companies, I'm not saying that, they aren't significant companies which are still in the large, still waiting resolution, issues are still pending. And even those who have been resolved, there are still litigation pending with them, right?
Yes.
Like only yesterday, we finished final arguments in the Supreme Court for Bhushan Power Steel, right? It's been, it's
But
one
it
of
has
the,
already been solved, that has already.
it's been
taken
resolved,
off.
but they've been continuing pending challenges and everything that litigation had to go through. So we've managed, like yesterday, Supreme Court, reserved orders on that. So there are issues. And for that, definitely, we do need to see that, we work towards better outcomes. But as I said, it's not about amending the law or rushing to amend the law. It is purely on implementation.
Yeah, please.
So I wanted to hear a little more about, say, the cross-border insolvency bit that you brought up. So the parts, draft part C that we have,
Right.
and ancestral model law has been differently interpreted throughout various jurisdictions, right?
Right.
So I wanted to hear a little about how that public policy standpoint in India affects the future of IBC and cross-border insolvency.
Right.
in that aspect.
See, in my personal experience, although a lot of people are talking about pressing need for cross-border, there is a need, and there have been companies in the past, present, and will be in the future where if we had access to a cross-border law, maybe we could have better traced the assets, etc., and all of that. But all I'm saying is that we need to think through and come up with this, and it's okay if it's taking some time, but whether we adopt straight away the model law on the cross-border insolvency or not, I think the benefit of model law adoption is that, there are a lot of automatic benefits that you get in terms of recognition and everything. And it's also something which is truly model and ideal in that sense, because it is not dependent on recognizing a foreign jurisdiction as the main jurisdiction of insolvency, just on the basis of whether that jurisdiction has subscribed to model law or not. There would be countries like, I think, Singapore, if I'm not incorrect, they would still recognize your insolvency even though you've not adopted the model law, because that's truly the global way of going about it, right? So I think it is helpful to do it. But if there are any specific concerns that we have about anything, it's okay to tweak that law or implement those features little later. But I think the consensus seems to be in the policy circles now that we're moving towards model law adoption. But in how much time, we'll have to see.
So
Can you also both of you introduce yourself? Would you?
my name is Purnajyoti Kuhar Thakur.
Yes.
I'm a law student. I'm my third year right now for the 5-year BA LLB.
Yes.
Hi, thanks for the talk, Misha. Myself, Binay, I'm a public policy researcher. I was a financial journalist earlier,
Okay.
so this talk was hard. Now, US has a lot of deep liquid capital markets, 70 to 30 broadly ratio capital markets is to banking sector, capital formation. The reverse is broadly the case in India. It's the banking sector driven financialization.
Right.
We don't have a liquid or deep corporate bond market.
Right.
Now, do you think that is one of the causes of why this insolvency mess as a culture, corporate culture, asset recovery, lack of whatever you call it?
Right.
Or is it the chicken and egg? Is the reverse true? Lack of an effective IBC, the reason for us not having a deep and liquid corporate bond market?
I think it works both ways. I think the law can help and be a catalyst to a deeper corporate bond market. And things changing in the commercial reality also, makes the law change. The reason I think we still haven't reached that deep bond market thing is, one, we've lagged behind on our intended timelines. If it was not 180, it was 270, even 330, it would have been fine. But now it's going far beyond, and it's not acceptable. It's taking away the predictability and the time value, a sense of an insolvency resolution process. The other thing I feel, this whole unpredictability about the treatment of secured and unsecured creditors is actually a very, very negative for the growth of the bond markets, because we often, end up also having chats with people who are looking at taking positions in the market. And the question to me would be, should I take a junior debt? Should I take a, senior debt? And my question back to them is that, do you think this company is going to survive for a bit or is going to go bust very soon? So the answer perhaps lies there, because in the long term, I firmly believe that the secure creditors' rights will be recognized. The whole, anomaly in our jurisprudence would be corrected. But for the time being, if you ask me, majority is the boss. So we have Committee of Creditors who are really, taking away the rightful rights of the super secured creditors. Like they're 200% secured, and they're still being told that you will also get 50% as we will get, because there is parity in all of us. We are all sitting in the Committee of Creditors. We are all equal, right? So I think that confusion is harming the growth a lot.
And just a quick follow-up, just a comment if you may have any on the creditor-on-creditor violence right now that is happening in US. Like a lot of the private equity-owned companies, with the rise in interest rates by the Fed, the marks are not happening on the balance sheets, and the junior creditors and senior creditors, there is a tussle going on. How do I mark it on my balance sheet? And they are just kicking the can down the road and not really realizing the asset value.
See, I think I don't know much about the US markets per se, but it's unfortunately or fortunately for all financial creditors, at the end of the day, how it looks on the balance sheet matters a lot, right? And that's why also a lot of times, I think we are not seeing the sophistication that we require from the Committee of Creditors in making the decisions in the floor of the COC, because they are just wanting to do what nobody can question, that if you get 20 rupees extra by following an unfair legal principle, then I'll do that, because otherwise, especially for public sector banks, CBC will come back and ask them that why did you sign off on that, right? So nobody is taking those mature decisions. And for that, I think the economy and the whole framework and the governing structure needs to mature, and we need to respect commercial decisions on credible basis rather than just nafa nuksan ke basis.
So Misha, we have an audience, and there are some questions on Zoom that I'm going to read out. And the first question is it true that IBC disputes are being prioritized by the judiciary or tribunals, while those falling under the company law are being relegated to the back burner?
That's true. For NCLT and NCLAT, it's very much true. So even though IBC is getting the priority, our lists are full of IBC matters. They're on the top of the board. They're still not moving fast enough, and Companies Act matters are taking a backseat. I won't say that for Supreme Court, but
for the
definitely for
NCLT.
NCLT.
The second question is, how important is it for the IB to possess technical skills for resolving these bankruptcies? Do we need more or better standard setting in this regard?
I think insolvency professionals have done quite a credible job in IBC, given that it just came into operation suddenly. A lot of infrastructure was not there, and it was learning on the go. So they did quite a big task in quite good manner. But of course, the quality matters from experience to experience, organization to organization, person to person. And ensuring that the entire insolvency cadre, professional cadres is of the similar quality is certainly a task that IBBI is looking at. But in that sense, some of them can improve, but I would really say that
I think the question is in the line of, so what we are seeing, for example, with other tribunals that
Right.
I am more familiar with in my work, which is like the National Green Tribunal and so on, is that we have a lot of people who are coming in who don't necessarily, like they might be bureaucrats, but with no specialized expertise in environment. And
right. So if we are talking about the members of the bench in NCLT and NCLAT, of course, for them as well, for a lot of them, and there is training which happens for all these judges, but because it's a new law, forget about NCLT and NCLAT, the Supreme Court judges don't have a background of this law. So that continued education definitely will help. And not only from the legal principles, they know their legal principles, because it's a very commercial law and there's a very specific intent how to operationalize that law. If they are made familiar with this, I think it will help the benches as well.
Right. And the next question is, what kind of benefits do parties get who actually delay the IBC dispute resolution process? Which part, who benefits
So the first of all, the one who benefits are the promoters.
Hmm.
They don't like getting admitted in time. They don't like resolution plans being taken up and things like that. There's non-cooperation. There's an incentive to delay and frustrate and parallelly try and give some settlement proposal. Sometimes there are genuine cases as well that, genuine business failure and they are the best people to revive and they are looking to persuade the committee to, give them a chance. Part of the strategy to persuade them is also to frustrate them. So delays help. The other kind of litigation is also happening actually, which is not intending at delays, is the intercreditor disputes.
Hmm.
So there's a lot of dispute amongst the creditors because of the lack of, everything that we spoke about right now, which is causing delay. The third one is the competition amongst the resolution applicants.
Hmm.
So that's also driving the delay.
Any other questions from the room or on Zoom? No. Yeah, okay. So I am going to take this opportunity of the lull to ask a couple of questions. So I think that if I were to sort of sum up what you've said here is that even though there are many pending issues that need resolution, both with respect to the jurisprudence as it has developed, especially the issues of secured creditors not having the priority, which is actually sort of turning company law on its head. Because this is what we read in company law, because the whole point, and, it goes back to what I was saying about mortgaging your property. The property is the security against which you get the loan, as opposed to just getting a loan. So apart from those issues and the issues of the implementation and delays, how relevant is, and I'm sort of just, kind of trying to elucidate the shifts in the philosophical principles of looking at this. We've obviously talked about the movement from debt being a crime to debt being circumstantial, and which is, I mean, the reason why I mentioned Little Dorrit was because that is precisely the point of that whole, novel, is to show how people in their circumstances get into debt, right? But at the same time, the story that you're telling about corporate debt, it seems that there is I mean, what I would like to know is that in your experience, how much of it is actually negligence or fraud? And in that context, because you had it up on your slide, but probably didn't have time to go through it. The Jet Airways case, for example, and for those of us who grew up in the 90s, there were only two airlines, Air India and Jet Airways. And Naresh, and it's interesting because in this case, like, he actually has been imprisoned, or at least is under house arrest, precisely because there was money laundering and so on. So the question then is it, I mean, given how ubiquitous money laundering is in our society, is it that it was the case that because of the bankruptcy they got caught, or was there like fraud in the thing? And how much percentage of cases where the promoters are in, like, being sort of put aside while they try to resolve the bankruptcy process? How much of it is fraud? How much of it is circumstantial negligence? I mean, obviously it is based on your experience, but you've had a decade-long experience. So just some estimates of what is going on.
I think it's difficult to say really in terms of numbers how much is what. But I would definitely say that there are many cases of deliberate non-payment and leakage of values and smart corporate strategies to avoid paying your lenders and deriving undue benefit from the companies. And in many, I think in the banking circle, it is given that we do understand that there are ways and means which bankers can't even fathom to control, right? There's obviously increasing monitoring, there are things being put in place to ensure that these things don't happen, but these are happening, right? But at the same time, there are cases which are genuine business failures as well.
Like COVID being one of those circumstances
COVID
where a
being
lot of
that,
business.
or sometimes there's just distress in a particular segment.
Yeah.
I wouldn't want to take names, but I do believe that some of the promoters who've been kept aside, from certain companies, perhaps they were not really at fault. They did their work, but they miscalculated the outlay as against what was coming in, but they actually did the work and there was not diversion, right? So there are all sorts of cases, and
So I guess, what I'm trying to understand is that, as I understood when I read about the Jet Airways case, for example, was that the law, the IBC itself doesn't really provide for penalties where there is criminal conduct involved, then you have to look at other laws.
Yeah.
So, then you bring in the PMLA or any of these
Correct.
other laws, the Enforcement Directorate gets involved. So do you think that the existing architecture of other laws, like the criminal codes, the
Right.
PMLA and all these other laws, are they enough to sort of address the problem of willful default as
Right.
opposed to negligence or
Right.
circumstantial distress? That's number one, the
Hmm.
first question. And the second question is like, so, the Shylock story, like, why are they defaulting because the lenders are usurious? Is there a problem with the way the lenders have organized the?
I think the fault lies on both sides. So equally, the lenders, and as we all know that over a period of time, bankers have, uh, you know, uh, allowed the loans to be revived and the extension in terms of repayment dates and etc. Uh, I'm forgetting the term, something like green. Anyways, that's fine. So all of that has happened, right? And it's also a function of the fact that they haven't had effective remedies, right? And it is ultimately they are also running a business, and balance sheet really matters. So sometimes, those decisions have also blinded an objective kind of decision making, which could have been done by the lenders at that time. As regards PMLA and all, I'm no expert. It is being used, but it's a long process. And what also happens is that when lenders are trying to preserve value and get the best outcome of insolvency, then say PMLA starting parallelly has also caused problems like in BPSL as well. And we had the section introduced in IPC for
You have to closer to the mic.
right. Uh, there was a section introduced in IBC that post if an independent entity was to take over the company, then the past liabilities, including of criminal offenses and all, will not continue on the assets of the company, etc. While there's a clarity post resolution, there's still a question what happens during the resolution, right? So if there's a PMLA working parallelly to an IBC, then how many resolution applicants would actually be interested in going on with this process? It does put a cloud over the whole thing. In IBC, if you look at a punitive kind of a thing or a corrective measure in case there has been a deliberate leakage of value, is under the tools of avoidable transactions, where you can avoid preferential transactions, undervalued transaction, something called extortionate transactions. Jurisprudence under that is still developing. In fact, because the CRP itself is such a hectic activity, I think in some ways fairly so. Maybe ideal world, even avoidance jurisprudence should have taken up, and those applications should have been expeditiously resolved. But there's a lot to do even for the credit of NCLTs in this 180 to 70 days. So they've been relegated to, the last thing to figure out at the end of the CIR processes. And we haven't seen many significant outcomes out of it, but those are tools to, retrieve value if it's been deliberately diverted.
Yeah. If there are no further questions, then, oh, there is a question on Zoom. Okay. So, are there any demerits of the IBC law? I mean, apart from the ones that you have listed, but you have listed more in terms of implementation and not
Right.
so much in terms
In
of the
terms of
text of the
design.
law, except for one drafting error that you mentioned.
I think we need to look at the whole designing of this law of financial versus operational creditors. Yeah, we need to maybe relook at that, and maybe like we're almost reaching 10 years of its implementation in next couple of years. I think we should look at whether, and with the MCA saying that now we will change the waterfall, which says that first secure creditors workmen and then everybody equally, right? This is actually going back to the traditional model, which divided the creditors as secured or unsecured, right? If that is the case, and what happens in the global jurisdictions is that It's not that somebody is just thrown out of the window and said that you don't have a voting. Everybody gets to vote on to the extent the particular plan or scheme affects their rights, right? While they may be unsophisticated workmen and all of that, or trade creditors, maybe the committee of creditors as financial creditors can take a decision whether this company should revive or it should get liquidated. But maybe it will be more fair that you give a voting right to, say, operational creditors on those aspects of the plan which are, affecting your interests. Of course, you have liquidation value and everything you'll have to see. We'll have to take a call, like whether an objective criteria, as IBC has provided very deliberately, the liquidation value is what you pay, and after that, sorry, don't contest. And if you give right to voting to operational creditors, they will want something beyond, liquidation value. And before doing that kind of a tweaking, I think that's one of the concerns about the way the law is designed. I think there should be empirical study on how IBC has actually affected the interest of operational creditors. If you were to take the example of Essar Steel, they have not gotten adversely affected at all. They've got paid 55,000 crores during CRP of 600 days. They get paid 20% of their pre-CRP dues and they get continued business, right? But it may be the rosy picture, right? Maybe the statistics will tell you an entirely different story. So, but I feel these kind of policy decisions should not be changed on the basis of my impression or your impression. There should be an empirical study to do so.
Right. So that brings me to, you touched upon it, like, and the workers and the people, the consumers of the products that those companies are making. What impact, or are there studies to suggest what impact has happened on them? And I just want to, compare, because I don't know enough about the IBC, but my sense is, and you can correct me if I'm wrong, that the Chapter 11 proceedings in the bankruptcy code in the US, the main focus is on reviving the company. And when the main focus is on reviving the company, the workers and the employees become a very crucial stakeholder.
Correct.
Whereas from much of the discussion that we've had today, it seems to me that they are not as crucial as stakeholder in India, partly because it seems that the creditors, the focus is more on the creditors rather than the company. And what does that mean for the economy, for things? And I'll just tag another question to that, which is that it's pretty clear in terms of India's economic policy that under this government and also in the past has been highly protectionist. And despite all of the reforms that have happened to clean up the mess, so to speak, under the India government, the protectionism has continued. So some might argue that from a economic perspective, actually more businesses should fail because if you open up the economy to foreign providers, it might be better for consumers and employees and so on. And we've talked about, protectionism is there in every sector. In our sector, the law firm sector as well. There is it's there. So it's
changes.
Should is it changing? Okay,
it seems like
we've been hearing that for 20 years. So I will believe it when it happens. But so for who? So IBC seems to be more for the creditors in India, Chapter 11 proceedings more for the company, which is why everyone is constantly going to bankruptcy, especially the airline sector. There are airlines that have been in multiple bankruptcies, the United Airlines bankruptcy one. So who is it good for? Which system is good for who? And a provocative thought to leave everyone with, should more businesses fail if we remove protectionism?
Right. So let me answer one by one. So insofar as workmen is concerned, they don't have a vote, they don't have a seat on the Committee of Creditors, but I think rightly so, because workmen can't possibly decide whether the financials of this company or the business model is something which is worth reviving. They have a stake.
But in the US,
right. But I don't know, economies are different and things like that. But insofar as their treatment under resolution plans, I don't think there is an empirical study should be done. But what I have seen is workmen and employees are invariably paid 100% of their outstanding dues, even though they are only required to be paid only liquidation value. Even, our advice is corporate law firms to the corporates given the resolution plans is, this is a simple a significantly less amount, insignificant amount. And from the optics from the courts, even though they don't have much of a discretion, you stripping workmen and employees of their rights is not going to be seen well, right? So we've always advised, and I have seen that workmen and employees are always paid full. That's one. Secondly, our IBC is also geared towards revival. I personally feel that the whole idea should not be either revival or liquidation. So in that sense, somewhere I understand what you're saying. I think it should be the correct economic decision. What is the right economic decision? What is the best use of these assets of a business to be put? Either should it be revival or should it be, winding down? And that will dictate a best outcome for all its stakeholders, because you're maximizing what you're getting from this thing. And insofar as whenever at either in a resolution plan or in liquidation value, again, workmen are the first priority, right? After costs, along with secure creditor. So to that extent, I think they are very much protected, but there is no prescription in law that when I take over your company, that I will continue to employ your workmen and employees, right? Whether that's happening or not, whether that continuity of enterprise is allowing that, is something which I think only empirical data can tell. About consumers, I think it is good to the extent that it allows a decision, whether it's reviving or it is exiting, and it is supposed to be time bound. What is hurting the consumer's interest is that there is a delay. This delay and predictability, of course, suffers, the business operations, and therefore the consumers will suffer. But if it is implemented in spirit, I think it caters to the interest of the consumers. About airlines, because you touched, I think again, airlines is another example like a real estate, where IBC standard procedure is not an answer for an airline. Even in case of Go Airs, they had to go ahead and, give a notification which exempted the leases, the airline aircraft leases from the operation of moratoriums, right? Those aircraft sitting in our airports, with our resolution applicants having not enough wherewithal and no funds to even keep them in good working condition. It was just a waste of an asset, right? So the government had to come up with a notification for that. So I think airline insolvencies are very complex and needs a very nuanced structure beyond the standard procedure under IBC. More businesses should fail or not? I think the answer I gave you, I think the ones should fail. We should not just keep them artificially on a ventilator. And those who are capable of reviving should revive. And that's where actually the creditors should be doing the real job, which they're trying to do. Maybe they're not up to the mark still, but we are all learning.
Thank you, Misha. You've really shed a lot of light on a dense subject matter. And I think for researchers in the room, this is an area ripe for empirical research. She's laid out the questions where, it would be helpful for, even for, lawyers advising clients, how is the system actually working? So I think she has shed light on what is her job, and now it is up to us to, create information that can sort of feedback and perhaps drive new amendments to the law. And it seems that there are multiple bottlenecks. Some in the understanding of the law, like it'd be nice to know how this law has made a change in terms of the economic, the changes that the law has brought, but also in terms of the resolution processes, the tribunals. And actually, Misha, our work on land acquisition, where we looked at, we were looking at it to understand the law of land acquisition and do an empirical kind of qualitative and quantitative analysis of all land acquisition cases decided by the Supreme Court. But actually, even though my goal was to look at land acquisition as a subject area, like you're looking at bankruptcy, it basically gave a lot of data on the problems with the judicial disposal of the cases and the delays and why that was happening. So I think that even analyzing all the bankruptcy cases that have happened and interviewing lawyers like you and others who represent other stakeholders would be a very important area of research for the future to understand how the law is working out. But in the meantime, thank you for introducing us and walking us through this area of law. And all the best to you as you sort of trailblaze
in this area and other areas of litigation.
Thank you so much and thank you for having me.